I will now hand over to your colleagues. We start with a panel on financial services. The panel will be chaired by Dr. Matthias Kurt, who is associate at CMS Zurich. He is a specialist in commercial and financial law, and his practice has a special focus on regulatory advice to financial services providers, regulatory and contract law advice to fintech and blockchain companies. So he will be introducing our next speakers, and I give the floor directly to him. Thank you very much.
Thank you, Eva, and hello everybody also from my side. First of all, I would like to also thank the ambassador for this great presentation, and as Miss Professor Lane already told you, I will moderate the panel on financial services, where, as you already heard from the ambassador, interesting developments are taking place between the UK and Switzerland. The panel comprises, except for me, three other panelists, which I may briefly introduce. The first panelist is Alexander Renkli. He is a counselor and head of the Economic Finance, Science and Innovation Department of the Embassy of Switzerland in London, and he represents the Swiss economic interests in the UK in the broadest sense. He also chairs the Association of Economic Representatives in London. Prior to this position, he headed the Financial Affairs section at the Swiss Foreign Ministry in Bern, and early in his career, he also worked in the private banking sector in Switzerland, but also in Japan. Then we have Nikola Olivier on the panel. He is a partner at the law firm Lalif in Geneva and specializes in banking and finance litigation, and regularly advises and represents clients in complex litigation cases in the field, also in front of the Swiss Financial Market Supervisory Authority, but also in state courts. He also was appointed in 2020 as a member of the governing body of FinZone, which is the first Swiss non-profit ombudsman organization, which has been approved by the Swiss federal government in accordance with the Swiss Financial Services Act. And in fact, these ombudsman organizations, for instance, also play a role when it comes to providing financial services into Switzerland. Then we have as third panelist Pippa Tasker. She's a partner in the London Financial Services Regulatory Team of CMS and advises on a wide range of regulatory and commercial matters affecting financial services providers. She also advises regularly on multi-jurisdictional projects and cross-border services issues, as well as regulatory change projects, such as those arising from Brexit, and is thus a very suitable speaker. In fact, since Pippa and me are from the same law firm, we also often handle cross-border projects of UK or Swiss companies together. I will not introduce myself anymore, as as Eva kindly did that already, and does suggest that we will now start with the panel, and for such purposes, Alexander Renkli will first provide us with an update concerning the status of the negotiations on the future of the British-Swiss financial collaboration. And after this presentation, the lawyers will provide some insights on the current practical problems they face and what they would expect from such future collaboration. Alexander, I hand over to you.
Thank you. Thank you very much for this very kind introduction. Good afternoon to everyone, also to my fellow panelists. I did prepare a few slides, and I would ask you to share them. Thank you very much. So I'm very happy to speak to you today on the future of Swiss-British financial sector collaboration. Of course, there would be plenty also to say on our relationship in a wider trade context, in particular when it comes to trading goods. And the ambassador has already mentioned the main issues, but I think we need to focus. Now, I'm not quite sure. Is it possible you don't see me on the camera, or is it all okay? Okay, I assume that it's okay. All good. Okay, excellent. Could I ask you to go to the next slide, please? Thank you. So as Ambassador Fasel already highlighted, in the past few years since the Brexit referendum, we've been closely working with our UK colleagues to make sure that the existing rights and obligations are safeguarded in line with the Mind the Gap strategy of the Federal Council. We have successfully put this strategy into effect at the end of the transition period between the UK and the EU, when a series of bilateral agreements entered into force, or as the case may be, are being provisionally applied, where the parliamentary approval process is still ongoing. Next slide, please. In the area of financial services, Mind the Gap meant that we were able to provide a seamless continuation of existing rights and obligation with a new agreement on direct insurance between Switzerland and the UK based on the Swiss-EU agreement. This is one of the agreements which entered into force at the beginning of this year as it was foreseen. In tax matters, Switzerland and the UK have been exchanging information on the basis of the global standard for the automatic exchange of information on financial accounts, the AEOI standard, since autumn 2018. This exchange of information is now being continued on the basis of a so-called multilateral competent authority agreement, as opposed to the bilateral agreement which we have in place with all EU member states, but in substance, it's the same thing. Also, the unilateral equivalence decisions the EU had granted to Switzerland had to be onboarded by the UK, as essentially their financial center, financial services laws are quasi-identical at the moment to those of the EU, as they have incorporated them as part of their EU exit process. But the Mind the Gap strategy is not only focused on securing existing rights and obligations, as we've already heard, but also focuses on areas for new opportunities. And in this particular area, we are now very much focused on when it comes to financial services. And in this context, I would first like to focus on the joint statement. So our two finance ministers, Federal Councillor Uli Maurer and the Chancellor of the Exchequer, Rishi Sunak, signed a joint statement in June 2020. In fact, it was signed virtually, and copies of the statement were shared across screens as that visit, which was planned to take place a bit earlier even, could not take place due to the pandemic. But this really was the starting point for the Swiss-UK process, which we are engaged in now. And if you look at the joint statement, you can easily find it. It is sort of a preamble of the ambitious and novel agreement which we are envisaging with the UK in the area of financial services, setting out the scope and the ambition of this adventure. Firstly, it states the intent of both countries to collaborate more closely going forward, whilst highlighting our common objective to foster open, safe, and sound financial markets. It also describes the scope of the agreement, which is provision of services to wholesale and sophisticated clients in the fields of insurance, banking, asset management, and capital markets, including market infrastructures. It sets out the commitments, protecting investors and consumers, safeguarding market integrity and stability. It establishes the mode, which is an outcomes-based mutual recognition approach, enabling the provision of relevant financial services from one jurisdiction into the other. And centrally, willingness to defer to each other's national regimes and supervisory practices. The joint statement also highlights that there is a desire to further deepen the already well-established cooperation in international fora regarding financial regulation. From a Swiss perspective, the goal of negotiating an ambitious mutual recognition agreement for financial services with the UK and a desire to deepen bilateral cooperation in international fora also fits very well into the Swiss government's vision and policy for the Swiss Financial Center going forward. And we hope that it's also an important signal to the world, especially in the context of the ongoing COVID-19 pandemic. During this period, as you will know, we have witnessed some protectionist tendencies. So our joint statement and the ambition to facilitate trade and mutual market access in financial services is, I hope you agree, a welcome contrast to that. Next slide, please. So let me now give you some context within which the agreement has to be seen and understood from Switzerland's point of view. The Federal Council presented towards the end of last year a report on its policy for a future-proofed Swiss financial center. As part of that report, a strong financial center was identified as key for the Swiss economy and its position as an internationally successful hub for economic activity and business location. The goal from a policy perspective is to maintain and support the position of Switzerland's financial center as world-leading, modern, and globally relevant. The Federal Council aims to assist and support us with a sound and dynamic financial market policy. Three key strategic thrusts were identified, and this is not in order of importance. So first, innovation. Existing institutions and new market entrants must be able to exploit the many possibilities offered by new technology and data-driven business models. The Federal Council wants to make sure that businesses can benefit from these new opportunities through a technology-neutral regulatory framework for digital access, digitalizing the interfaces with the authorities, and promoting innovation in the financial sector. Interconnectedness. As a mid-sized, open, and highly productive economy, Switzerland relies on and is committed to fostering international interconnectedness and open markets, especially in the financial sector. International standard-setting bodies have an important role in this regard, as they are continuously refining the international financial market regulatory framework. Switzerland is actively engaged in these discussions, and the Swiss government also represents its overarching market access interests in these bodies. Furthermore, the Federal Council also aims to set an overall attractive regulatory framework for a financial center with a global reach, which is in line with international standards. The third point, sustainability. So the third key thrust of Switzerland's financial center policy. This means that for financial service providers, as for all sectors of the economy, sustainable growth is the only path forward, or rather that's the analysis. In this context, sustainability encompasses the fundamental stability of the Swiss financial sector as such, its integrity and ability to combat criminal risks on the one hand, but on the other hand, against the background of the 2030 Agenda for Sustainable Development, and especially the global need to fight against climate change, it also covers the tools that are needed to ensure that there is transparency regarding investments, quality of services, and effective product prices. So all these are preconditions for investors to understand what and make a difference between what is a sustainable investment and what is not. Next slide, please. Now, in order to implement these three strategic thrusts and to turn the envisaged policy into a reality, several puzzle pieces need to come together. In its report, the Federal Council identifies several areas of action. One area of action with regard to the interconnectedness of the Swiss financial center is the topic of market access. In this regard, Switzerland aims to find workable market access solutions with our European neighbors. As previously mentioned, the joint statement shows we are very pleased that with our UK counterparts and friends, we now have a like-minded partner who is also interested in developing a solution in this area. The joint statement confirms that we are both looking to develop an ambitious mutual recognition agreement. So what does that mean? What is the objective? This is firstly an outcomes-based mutual recognition regime for regulatory and supervisory frameworks. It's a seamless cross-border market for financial services in the areas of banking, insurance, asset management, and capital markets, including market infrastructures. It will include sophisticated services such as private banking and wealth management, which I think is fair to say is more important for the Swiss financial center than the British financial center, but also wholesale business, which is of course the strength of London and other financial centers in the UK. It could well be a new model on how to structure relationships between like-minded jurisdictions in a world that is becoming increasingly fragmented and complex. Since the signature of the joint statement in the early summer of 2020, our two treasuries, which have the specialists, have started to put flesh on the bone and to work on the substance of the agreement or the idea of mutual recognition. At the beginning of this year, both our finance ministers met again to take stock of the progress made in the exploratory talks, which had been held in the second part of 2020. They gave a positive assessment of these talks so far and agreed further steps for more concrete negotiations to begin on individual topics concerning the MRA in the first half of this year, or these are ongoing as we speak. These discussions have started, and I'm pleased to say we are quite hopeful that they are progressing well. And just to remind, and I believe the ambassador has already made this quite clear, this is an ambitious endeavor since there is no international template for what we are trying to achieve with the UK. And so in many ways, Switzerland and the UK will have to lay the groundwork first for an agreement as the one we have just mentioned. Against this backdrop, close interactions and exchanges between government representatives and the industry have taken place, and these have proven to be very, very productive. A position paper on, and I quote, future-proofing the UK-Swiss financial and related professional services relationship was released jointly in April 2020 by the two industry bodies, Economie Suisse on the Swiss side and the City UK on the UK side, which had worked very closely with the key stakeholders in the respective financial services sectors. And this document was a welcome source of inspiration for our government, certainly, and I believe also for the UK government. Government representatives have had further chances to link up and exchange views with industry representatives in an industry roundtable in September 2020, ahead of the annual Swiss-UK Financial Dialogue. So UK government and industry, they are very much aligned on both sides, UK and Switzerland. Going forward, the interaction between government and industry will remain important to shape the future relationship between Switzerland and the UK in financial services, to ensure that we deliver real practical value with that envisaged MRA. To conclude, we are deepening at the beginning of a journey to deepen our collaboration with the UK in financial services, building on an already very close collaboration between our governments, be it in the multilateral area when it comes to standard setting, or with regards to more thematic topics such as sustainable finance. Our annual financial dialogue serves as an important element to nurture our bilateral relationship. Our relationship in financial services is already very deep, and we hope to enhance it even further going forward. I think I will stop here for now. Thank you very much.
Thanks a lot. I seem to be freezed. Okay, now
I can see you.
Looks better. Okay, I was freezed on my screen. Maybe I ask Nicolas first how he would see the collaboration in the financial sector between Switzerland and the UK as a lawyer supporting Swiss companies doing business in the UK and probably also UK companies doing business in Switzerland, and whether he has any points in mind which should be specifically addressed within the realm of such a future agreement. Alexander, can you, no, not Alexander, I'm sorry, Nicolas, can you provide us some insights on that?
Thank you, Matthias. Good afternoon to everybody. Yes, of course, because, Switzerland is a third country in relation to the EU, and now the UK is also a third country. So we have two third countries that now are free to conclude an agreement on the financial services. Actually, the UK is now facing the difficulties that Switzerland has been facing for many years to access the EU market. It's a very complicated topic, and to address it, I wanted first to summarize actually the different types of levels of market access that are available. And to do that, I need just to go a bit back and explain a few points about MiFID II, because before Brexit, UK firms had under MiFID II the right to provide cross-border investment services in all other European countries without any local regulatory approval. Post-Brexit, transition period ended on 1st January 2021. And the financial services are not included in the December 2020 UK-EU trade deal that was concluded. With Brexit, UK firms lost the right to passport into the European Union, and UK firms, like Swiss firms, are now required to open a branch in the EU to get the passporting rights. UK is now, like Switzerland, a third country outside of the EU. For Switzerland, market solutions, market access solutions are close bound up with the conclusion of an institutional agreement between the EU and Switzerland, and negotiations are currently facing difficulties. Likewise, for the UK, the market access depends on a specific agreement between the UK and the EU. The agreement thought between Switzerland and the UK is to be based on the principle of mutual recognition of the applicable financial market regulations and the relevant supervisory framework. But it remains to be seen, in my opinion, what areas and types of financial services will be included in this agreement, and also what will be the conditions to access the markets. I noticed that in the June 2020 Joint Declaration of Intent, there was a reaffirmation of the goal of the ambition to liberalize and expand the mutual market access in the area of financial services. But a key matter, in my opinion, is whether retail clients will be included in this agreement or only professional and institutional clients. In this regard, I noticed that in paragraph 5 of the joint declaration, it is indicated that there is an intended focus on the provision of services to wholesale and sophisticated clients. If we define these terms, wholesale and sophisticated clients, in regard to the new Swiss financial market laws, it means that it will concern basically banks, insurances, central banks, pension funds, and large firms with treasury which are managed professionally. It will not concern high net worth individuals who have, of course, the option to opt for the classification of private clients, but from my understanding, for the time being, they will not be included in this agreement with the UK, it's also very crucial for Switzerland, in particular Geneva, which is a very important place for cross-border wealth management for private clients. Well, Switzerland is actually the global leader in cross-border wealth management, followed closely by the UK. And I hope that private clients will be included in this agreement, because you have different levels of access to the market. Even under the current MiFID II, there is actually a different frameworks. You have a first harmonized framework concerning eligible counterparties and professional clients. So to get access to the EU market, Swiss banks will need actually an agreement with the EU to obtain equivalence decision, and among other conditions. But the most important requirement in this equivalence decision, which we try to obtain for many, many years, it's a bit like the Holy Grail, which we never find and are always looking for. And that actually, this harmonized framework could be achieved if we obtain this equivalence decision, and Swiss banks will have access to all the professional clients and eligible counterparties wherever they are located in the EU. That seems to be actually the type of level market access we try to achieve now with the UK. But you have a second level of access which concerns the retail clients, which is not harmonized under MiFID II in the EU, where member states remains free to apply their national rules. In other words, each member state may require Switzerland or Swiss firms to establish a branch in their state in order to provide investment services to retail clients. And that it's a huge obstacle for Swiss banks. I had a client a few weeks ago that was trying to conclude an escrow agreement with a Swiss bank, and my client was located in Italy, and you face many obstacles to actually provide financial services to a client located in Italy, for instance. My client was not allowed to sign the opening account documents as it was prohibited by Italian law. It was not prohibited by EU law, but by Italian law, and it was a barrier to the access of the market. So we had to structure it completely differently, and when they provide us with the power of attorney, and as a lawyer, I executed the opening account documents, and then there was all a debate about what to do with the signature cards, because the signature cards had to be signed by the directors of the company. And well, with the COVID, it was quite complicated to travel even to Ticino. So that are actually the difficulty that Swiss financial service providers are facing. And well, I hope that retail clients will be included in the UK-Swiss agreement that would really ease the access to the market, the UK market, and also the Swiss market for UK firms. That would also reduce the costs and the complexity of a very heavily regulated financial industry. And it would make life easier for many Swiss firms providing financial services in the UK. Without waiting for an agreement, many Swiss banks have actually incorporated an entity in London to serve UK clients and to and provide also advisory services from London, even sometimes to Swiss clients, as the products are created in London and then distributed in Switzerland. But I will not enter into all the details of the current rules applying to UK firms to provide services in Switzerland, as my colleague Pippa will address this point. What I wanted also to stress is the importance of recognition of anti-money laundering checks and the equivalence of anti-money laundering regulations, because it's always included in any project when you want to do business between Switzerland and another country, especially in Europe or in the UK. And it's quite vital because, well, even if you are a fintech company and you can benefit from a sandbox regime, you are still subject to anti-money laundering regulation. And to compare between the countries, the type of regulations, it's extremely complicated, and it's not exactly the same requirements and the same conditions that are required from financial service providers. I had a Portuguese bank that wanted to actually be involved in a fintech in Switzerland to distribute fixed term deposit. And well, they had to actually know if they could rely on the KYC of a Swiss bank. And it was extremely costly and complicated to structure an agreement between the two banks in order to abide the Portuguese and the EU law. So that, I think, would be a very hot topic to include in a UK and Swiss agreement. I wanted to conclude by saying that the UK-Swiss agreement is the opportunity to set a high standard for all similar agreements with other countries, including EU countries, because for the time being, Switzerland is still seeking some, I think, other agreement with EU countries to access their retail market. Switzerland reached an agreement with Germany. So under certain conditions, Swiss banks can provide services to some clients in Germany, but Switzerland is still trying to expand its network. Matthias, I hand it over to you.
Thanks very much, Nicolas, for these practical insights. And I guess we continue directly to Pippa, who will give us the UK perspective and mainly what the obstacles that her Swiss clients face when they want to provide financial services into the UK. Pippa?
Thank you, Matthias, and good afternoon, everybody. It's been really great to actually hear His Excellency's and Mr. Ringley's comments on mutual recognition and an outcomes focus in the relationship between Switzerland and the UK, and those points reiterating what we've seen in the press. And I personally have hopes that this means the agreement will, in fact, expand the cross-border provision of services using home country rule, which will alleviate many pain points for my clients, though, as Nikola flagged, it will be quite interesting to see the detail when it comes out. This approach is indeed ambitious and, to my mind, is far preferable to a line-by-line comparison of the respective regimes, an approach which only grants limited reliefs, which is more akin to the application of the financial services equivalence regime as it's applied under the EU directives. I think to explain why I say that, and perhaps also underscore why this mutual recognition approach is so novel, equivalence was a term that was used a lot during the Brexit negotiations between the UK and the EU in the press and in commentary, with many people thinking that a raft of equivalence determinations were going to be this silver bullet, which would give financial services firms in the UK and in the EU continued market access and would give them freedoms very similar to what they had enjoyed under the EU passporting regimes that Nikola just described to you. And to be honest, I presume many people are hoping for the same in the future UK-Swiss relationships. But in fact, this wasn't the case, because equivalence under the EU directives, and as the UK actually approached it post-Brexit in their relationship with the EU, it's not one singular determination, but rather it's something which is assessed individually and sometimes very differently in relation to each of the different areas of financial services, deposit taking, insurance, asset management, and something which can even be split into a number of different headings within each of those areas. So, for example, it was entirely possible that a country may be found to be equivalent in one area, say of insurance law, and granted certain rights or privileges there, but not in another. The example that comes to mind is the European Commission decided that Switzerland was Solvency II equivalent across all three possible areas there. But some countries, including Australia and the USA, were only deemed to be Solvency II equivalent for group solvency purposes. And for those of you who aren't in the mires of insurance law, basically, that meant that any EEA groups which had third country subsidiaries, they could use the local capital rules for their subsidiaries, which were located in a third country, rather than having to apply the Solvency II rules. But Australia and the US, for example, were not deemed equivalent for reinsurance purposes, which meant that any reinsurance contract that was entered into with a reinsurer in one of those countries, they're not treated the same in the same manner for regulatory purposes as contracts entered into with EEA reinsurers. And that's obviously a very big blocker for the potential customers of those reinsurers in the EEA. So in addition to this complex and rather fragmented approach to equivalent, and perhaps more importantly for the current discussion, equivalence as applied in the EU is not actually linked to market access rights in an explicit way, and certainly not, as I said, in the way that many people in the financial services sector actually hoped it would be. But excuse me, equivalence provides instead for reliefs from the general treatment of foreign firms. So put simply, if the agreement were only to apply the principle of financial services equivalence as applied by the EU, then certain rights would be granted in certain specific areas and only under some, but by no means all, of the relevant UK legislation. And I think Swiss firms in particular would find, well, they were unlikely to find themselves in a much better place in terms of UK market access than they are currently, which is why I'm so cheered by the comments from the speakers. Speaking of the place that the Swiss firms currently find themselves in, to give a reminder of what it is which might be changed and why there are challenges. To date, Swiss firms operating in the UK have faced a very restrictive regulatory landscape and significant difficulties in many areas of financial services if they are not either working with or through a UK authorised entity, whether it's a branch in their or a subsidiary within their own group, or a completely separate UK authorised third party, or unless they found themselves servicing relationships which were developed entirely outside of the UK. So perhaps dealing with clients who had immigrated to the UK once the relationship had already been formed. Why are there these difficulties? Well, in short, as many of you might already be aware, it is a criminal offence in the UK to carry out any one of a number of specified regulated activities unless you are either UK authorised or exempt. And not only that, the UK has a financial promotions regime which is far broader than one that applies in Switzerland or most of the EU, which broadly speaking, prohibits anyone who is not UK authorised from communicating an invitation or an inducement to engage in any kind of investment activity, unless that communication has been signed off by a UK authorised firm. So again, you need somebody here who is authorised in order to facilitate some access. So what these 2 points mean is that Swiss firms have largely had to rely on the exemptions and exclusions which apply to overseas persons, which is defined as anyone who does not operate from a permanent place of business maintained by them in the UK when they're carrying out those regulated activities. And in addition to that, rely on various carve-outs to the UK financial promotions regime, which vary depending on the product concerned, the service being undertaken, and who the client is, whether they are retail or professional. Now, I'm conscious of time, so I don't plan to drag you through all of the detail of those, although I'm happy to do so later if anybody would want. But the analysis, in essence, the analysis of what can be done and how, and the practical application of those rules can be very complex and costly. So suffice to say, I'm sure that a more frictionless regime which enables Swiss providers to offer and promote financial services, particularly to UK retail clients, would be very welcome, even though I have to admit that it would obviously reduce the amount of work that I have going forward. And I guess Briefly, though, on the other side of that coin, my UK clients have generally found Switzerland to be far more open, though the recently revised legislation in relation to financial advisors has arguably changed that, leading to a number of them seeking Matthias's expert help. And so actually on that note, Matthias, shall I pass back to you?
Yes. I mean, I also being conscious of time, may briefly address three topics which our UK clients face when they want to provide financial services into Switzerland. The first topic is also kind of the financial promotion topic, in particular in the funds field, which is an important one for Switzerland, since, as you might know, in Switzerland there are a lot of investor located. So Switzerland is rather an investor jurisdiction than a funds production jurisdiction. And with these recent laws, the Financial Services Act and the Financial Institutions Act, it has actually in some aspects become more difficult to distribute funds into Switzerland. For instance, if you wanted to distribute to high net worth clients, you would, unless there's a reverse solicitation, have to first register the individuals that will contact the Swiss clients with a advisory registry. Then you would have to affiliate with a so-called ombudsman office, which is the office that Nicholas is somewhat presiding, one of those. And then you would also have to adhere to the FINSA rule of conduct, which are similar but actually not the same as the MiFID rules. And then furthermore, in the field of fund distribution, you would have to appoint the Swiss representative and the Swiss paying agent. As you see, there are thus merely to distribute a foreign fund into Switzerland to high net worth individuals, quite a few work streams to be covered, which is obviously rather cumbersome. Then a second example would be the provision of cross-border asset management services. Here, in fact, we have a regime which is supposed to be liberal, since basically in order to do cross-border asset management into Switzerland, you would, as per the law, only require a license if you have a physical presence here. However, FINMA interpreted these rules rather strictly and says that also companies that hold them out to have a physical presence here fall under the licensing regime. And in addition, companies that have employees that travel into Switzerland for meeting clients and so on might be deemed to form a physical presence. And we recently discussed with FINMA how long they would need to be here in order to establish a physical presence, but there is no practical guidance to that end yet. And if you would need to obtain this license, it would probably be a so-called bright license, which is a quite costly license. Therefore, under the new laws in some, also cross-border asset management into Switzerland might well require a license under certain circumstances. And obviously now, if we have the UK asset manager that would be licensed in the UK and on the basis of a recognition of this license could provide also the services into Switzerland, that would be would make things much easier. And the same in the funds field. And rather from a Swiss perspective, and also as concerns the innovation topic, we have here a quite advanced fintech regulation, including a specific fintech license. But clients often come to us and ask us, what can I do with this license abroad? And then we tell him, look, this license is not really recognized elsewhere. And then they often turn around. And therefore, obviously, if also in this field, as the UK is also a very innovative jurisdiction, some kind of recognition regime could be established, that would also be very helpful. And maybe, Ms. Line, do we have still time to ask a few questions? I would have one or two to.
Yes.
Okay. Maybe to Alexandra, as we just have discussed this. Has it also been discussed, first of all, that kind of this fintech topic will be covered in the future collaboration between Switzerland and the UK? That would be my first question. And then referring back to Nikola's, is it the intention that also the provision of financial services to retail clients will be included?
Yeah, thanks for these two questions. I will probably appear a bit tight-lipped because given the fact that these are ongoing negotiations, I really cannot do much more than to point you towards the joint statement. This does set out the scope. When you say retail, and I believe if I understood it correctly, this is a question of how you legally define it. As I said in my presentation, it is clear from a Swiss perspective that when we say in the joint statement, sophisticated clients, that we would want to have a situation whereby we could, for our wealth management and private banking industry, that they would be able to have easier access to UK-based private banking clients. So for this part, that's quite clear. But retail, in the sense that it's that the ambition would be, to really have retail banking business opening up. I believe that's not part of the scope as per the joint statement. And the same is true also when it comes to fintech, as it's not listed in the joint statement at the moment. But as I said, I don't want to preempt, or I cannot preempt, the ongoing discussions. Maybe just as food for thought, the UK has agreed a number of fintech bridges with various jurisdictions. And if you want to read up on that, you'll see that Switzerland is not part of that. My interpretation would be that that would be the UK's approach to look into deepening cooperation in fintech on a bilateral basis.
Okay, thank you. And I think we have a question from the public, which is also rather specific. It's from Miss Katharina Gachter. It asks whether in case of a dispute, is the agreement to be interpreted according to the civil or common law tradition, And are there any specifications thus far as to how the judicial panel must be composed? Are there already insights to that end, or is the positions here kind of the same as with regard to the other two questions?
Yeah, no, I think you've guessed it. I really can't say very much specific in that area. I mean, of course, there will have to be a mechanism within the agreement, but yes, I don't think that I would be and anybody else would be in a position to already comment on a question that specific now.
Okay, I think if I don't see any further questions currently, therefore I thank the audience for this part and pass over again to Eva.
Thank you very much. I think in the interest of time, we probably move straight on to the next panel.